Yuba-Sutter.live's local government live streams are presented by Plumas Lake Self-Storage in Plumas Lake, where lifelong local residents are helping other residents keep things safe, providing indoor storage units, outdoor RV and vehicle parking, moving supplies, and Penske truck rentals. Details at plumaslakeselfstorage.com.
I'm Lieutenant Susan Jensen, and I'm here on behalf of Sheriff Anderson and the Sheriff's Department. I'm here to give you a presentation on Government Code Section 7283, which is also known as the Truth Act, and Government Code 7284.6, also known as the Values Act. There are two parts to the Truth Act. The first part went into effect January 1st, 2017, and established certain requirements for how law enforcement processes certain requests we receive from U.S. Immigration and Customs Enforcement, also known as ICE. The second part of the Truth Act went into effect January 1st, 2018, and it requires that local law enforcement conduct a community forum on an annual basis in which we inform the Board of Supervisors about our compliance with the Truth Act over the last year. That is why I'm here today in front of the board to talk about what our compliance was with the Truth Act for the year 2024. Before I review the statistical data regarding our compliance with the Act, I want to review the requirements of the Truth Act. The Truth Act states that if ICE requests or seeks access to a person detained or in custody of local law enforcement, ICE must make this request in writing. In turn, we are mandated to notify the person of the request received by ICE and notify the person if we, Yuba County Sheriff's Department, intends to comply with the request. This complies with Government Code Section 7283.1. The Truth Act also mandates that we track all records related to ICE access, and all communication with ICE are public records under the Public Records Act request. The Truth Act identifies 4 ways in which ICE may seek access to a person in local custody on local charges. The first one is an interview. ICE must seek this in writing. The interview is strictly voluntary, and the inmate may decline to be interviewed or may choose to be interviewed only with his or her attorney present. The second way in which ICE may seek access to a person in local custody on local charges is that ICE may request a release date for a person that is in our custody. This request must be in writing, and the inmate must be informed of the request. SB 54, which is the California Values Act, went into effect January 1st, 2018, impacted when we can provide a release date to ICE. We can now only provide a release date to ICE if the inmate has certain criminal history. The criteria listed is in California Government Code 7282.5 and 7284.6, parenthesis A, parenthesis C. Most of these are all violent crimes. The third way is for ICE to request an ICE hold. ICE may request to place a hold on a local inmate requesting we maintain custody of the person beyond their local release date. This is to give ICE the opportunity to make arrangements to take the person into their custody. ICE historically did this by providing us a Department of Homeland Security Form I-247A, commonly known as a detainer. SB 54 prohibits us from honoring a hold based on a detainer. We can now only honor a hold from ICE based on a judicial warrant based on probable cause, and the warrant must be signed by a magistrate. Lastly, ICE may request a transfer of custody. ICE may request that the facility help facilitate transfer of local custody to the custody of ICE. SB 54 now requires we can help facilitate a transfer of custody if the person has the same criminal history as previously mentioned in the release date section, and there is a judicial warrant, same as a hold request. In the year of 2024, we received 0 requests from ICE for interviews. We received 5 ICE detainer DHS Form 1-247A. We received 0 requests for transfer of custody. We received 5 release date requests from ICE. We did not comply with 8 of these requests due to them not meeting the requirements listed under SB 54 or being out of custody when we received the request. One of these requests is still pending based on a pending court case, and we honored 1 request for advance notification of release. Per the California Values Act, pursuant to Government Code Section 7284.6, all law enforcement agencies that participate in a joint law enforcement task force for which a California law enforcement agency has agreed to dedicate personnel or resources on an ongoing basis will be required to submit a report annually to the Department of Justice. For the purpose of this mandate, Joint Law Enforcement Task Force is defined as at least one California law enforcement agency collaborating, engaging, or partnering with at least one federal law enforcement agency in investigating federal or state crimes. The designated law enforcement agency must report the total number of people arrested for immigration enforcement purposes as part of this required reporting to DOJ. Under the Values Act, no California law enforcement agency shall participate in the arrest of persons for immigration purposes, even as part of the task force, unless the arrest meets the conditions of Government Code 7284.6, subdivision B1. We submitted the Values Act task force participation to DOJ on December 18th, 2024. The total number of people arrested for immigration enforcement purposes is 0. That concludes this presentation on our compliance with the Truth Act for 2024. Thank you.
Thank you. Any board questions or comments? Okay. Any public comment on this item? Okay. Seeing none, I'll close the public hearing, and there is no action. Is that correct? This is just receive a presentation. Okay. Great. Thank you. Okay, next we're going to move on to our 1:30 p.m. cost accounting hearings. Natalie, would you read the opening paragraph?
If a party to a hearing before the Yuba County Board of Supervisors seeks to challenge in court a decision of the board pursuant to Yuba County Ordinance Code Section 1.16.070 and California Code of Civil Procedures Section 1094.6, any application for judicial review of such decision must be filed in the appropriate court not later than the 90th day following the date on which the board decision was made. And through the chair, do we have anyone who needs to be sworn in today? Yes? If anyone who needs to be sworn in would please stand and raise your right hand. Do you solemnly affirm under penalty of perjury that the testimony that you shall give in the matter now pending before the board shall be the whole truth and nothing but the truth? Thank you.
Okay, thank you. Okay, thank you, Natalie. We'll move on to item 106, 2025, Community Development and Services Public Hearing, Cost Accounting Hearing to determine enforcement costs and penalties to be assessed against property located at 17383 and 17388 Ponderosa Way in Brownsville. And I'll open the public hearing.
Through the chair, is this the Ponderosa Way?
Yes, correct.
There we go. All right. Good afternoon, Chair, members of the board. Anthony Centillion here with cost accounting for item 106. It's a cost accounting for an address located at 17383 and 17388 Ponderosa Way in Brownsville. APN 050-200-005. So this is not an appeal hearing regarding a public nuisance because an appeal was not timely filed. That determination is final, and any regards to a public nuisance cannot be considered at this time. I have prepared a PowerPoint presentation which illustrates the violations of the Yuba County Ordinance Code for your consideration, and it is not intended to raise any questions regarding a public nuisance. Therefore, your considerations today are limited to the following three options, which is if the enforcement cost in the cost accounting is accurate and reasonable. Second is if in enforcement, excuse me. Second is should an enforcement cost be placed on the property tax bill as a special assessment? And third, should an abatement lien for all costs and penalties be included with the county recorder? Please accept my written staff report as a portion of my testimony, as I believe it contains information important for you to make your decisions today. So some of the things that we'd like you to consider: the danger to public health, safety and welfare, culpability, willfulness, the effect of the violations on the surrounding properties and the community, reasonableness to corrective action, recidivism, and the credibility of testimony. So an overview of the property itself, it's located near LaPorte Road in Brownsville. Here's the property details. It was acquired in 2020, is currently delinquent since 2021, and there are no permitted upgrades on the property, i.e. no structures that are approved on the property itself. All right, and so in May of 2022, the case was opened pursuant to a marijuana investigation by the Yuba County Sheriff's Department. In May 18th, a notice and order to abate was issued for the violations of 1,232 plants, outdoor grow, unpermitted structures, and junk trash debris. March 6, 2023, the marijuana violations were corrected, and the unpermitted structure is still standing on the property itself. So August 28th, 2024, a demand for payment was issued, which remains unpaid to this date. So here's a little bit closer image of the property itself. You'll see on the north side, you'll see two unpermitted greenhouses, as well as just below that is the unpermitted residence. Here's a closer image. It shows some of the items that were used in their cultivation. You'll see on the left side a barrel with some chemicals and the greenhouses itself. Here's an example of the plants as well as the electrical issues. And this is some of the junk trash debris as well as the unpermitted structure that was built without permits. Here's more items used for the electrical generators, and extension cords were used throughout the entire property. And this accounts for 19.75 hours. Here, I'll move this out of the way. For a grand total of $153,000, $140.62. So I have prepared a draft FCO with my recommendations, which is to adopt the FCOs as written, find that the enforcement costs and penalties as exhibited in the cost accounting are accurate and reasonable, order that the amount in the enforcement in the amount of $8,140.62 be placed as a special tax assessment on the property tax roll. And finally, order that the enforcement costs and penalties in the amount of $153,140.62 be recorded as a property, an abatement lien with the property, with the county recorder, excuse me. Any questions?
Questions or comments from board members?
I have a question through the chair. If there's an unpermitted structure on there, you guys have to keep going back? Are these going to go up?
No. So we ended up recording a notice of noncompliance. So once the property sells or changes hands, it's something that's buyer beware, and it notifies the potential buyer that there are issues and an unpermitted structure on the property. but that's something that's basically being held by the building department.
Through the chair, is there anybody presenting from the property owner's side on this, or is this just?
The property owner is not present. We haven't had contact with him in quite some time now.
Okay, I just wanted to make sure we give consideration, but the importance of these fees being collected is the compliance piece of this, and I think our county does really good with pushing forward with marijuana compliance. So the clarification question I have, though, is that the 290 days at $500 per day. So did they continue to operate through that, or was that just they didn't comply?
There was no compliance. There was a lot of communication between the property owner and the person that was listed as a property manager, but they ended up not complying right away, and that's where the fines or the penalties came in, and then we ended up losing contact with them after a while. So I believe it's been about a year since we've actually had contact with them. And we gave them the opportunity to correct the violations or correct all the violations within and they said they were going to try and get the structure permitted, which it never actually happened. So that's what brought us here today.
Thank you.
If I could, through the chair, could you explain what the $500, excuse me, what violations were associated with that?
There were still some tarps that were used in the grow. There were some other items like the water containers, as well as some like PVC piping that was used for the grow. And those are still items that were associated with the grow and became penalties, as well as the unpermitted structure. So each violation was supposed to be $100 per day.
Through the chair, Jeremy Strang. Yeah, I just want to qualify that statement is that the ordinance points us to apply an administrative penalty when violations are found to exist. It calls out that violations are at $100 per day per violation. Each plant is considered a violation by ordinance. And then as we go through our notice and order, and it's essentially a checkbox, we add up those checkboxes. So as Officer Centillon has pointed out, that yes, those are the violations that had not been removed that constituted the $500. Does that answer the question appropriately?
Okay, any other board comment or question? Okay, seeing none, any public comment on this item? Okay, we'll close the public hearing and entertain a motion for these items right here.
I'll make a motion that we order the enforcement costs in the amount of $8,140.62 be placed as a special tax assessment on the property tax roll, in order that the enforcement costs and penalties in the amount of $153,140.62 be recorded as an abatement lien with the county recorder.
I recommend that the motion also include the first 2 points on the slide, or you could just say, move the recommended action.
I make a motion, we adopt the recommended action. Does that work?
Okay, second. I have a first and a second. Roll call vote, please.
Supervisor Vasquez is absent. Supervisor House.
Yes.
Supervisor Fuhrer.
Yes.
Supervisor Bradford.
Yes.
Supervisor Messick.
Yes.
Motion passes. Thank you.
Great, thank you. Next, we'll move on to item 105, 2025, Community Development and Services Public Hearing, Cost Accounting Hearing to determine administrative and abatement costs to be assessed against property located at 1823 Heil Avenue, Apartment A in Linda.
I did. It says it stops screen share. Okay. There we go. So once again, Chair, members of the board, Anthony Centillion here with Code Enforcement. Here for item 105, which is the cost accounting for 1823 Heil Avenue, Unit A in Linda, California. APN 021 051 017. Now, I would like to point out that the property owner, Kieran Preet Kaur, is here with two representatives for your consideration. So, once again, this is not an appeal hearing regarding the determination of a public nuisance. Because the appeal was not timely filed, that determination is final. And anything regarding a public nuisance cannot be considered at this time. I have prepared a PowerPoint presentation which outlines the violations of the Yuba County Ordinance Code and is not intended to raise any questions regarding a nuisance. So essentially, we're asking that you agree that the cost reflected in the cost accounting is accurate and reasonable, that the administrative and abatement costs be placed on the property tax bill as a special assessment, and an abatement lien be placed on the, for all costs be placed at the county recorder. So please accept my written staff report as a portion of my testimony, as I believe it does contain information important for you to make your decisions today. So here are the discretionary factors once again. So Heil Avenue, this is a Google Earth image, which shows the location of Heil Avenue and the location of the house, which is located right off of Hamilton Smartsville by Simpson Lane, and is approximately less than a quarter mile to the Linda Elementary School. Here's the property details. It was acquired in 2020, and there are permitted structures on this property. So the timelines, important dates. The case was opened in October of 2021 for issues of septic issues, sewage spilling onto the ground, hazardous electrical, and we've had numerous code enforcement officers dealing with the property owner or the property manager during that time for the next couple of years to gain compliance, at which point in June 5th, 2024, a notice and order to abate the public nuisance was issued. And 2 days later, June 7th, 2024, the property was posted unsafe. And July 22nd, 2024, the compliance was verified. All the items were corrected. And July 23rd, 2024, a demand for payment was issued, which remains unpaid to this date. Here's a little bit closer image of the property itself. To the left side of the building, there was the kitchen was leaking sewage onto the ground, and it was just collecting. And I'll get to that image here in a little bit. Here's an example of some of the issues on the property, some junk trash. On the right side, we believe this to be a unused or abandoned septic. And on the left, there's some sewage that has been disposed of on the ground, or at least leaking onto the ground surface. So once the repairs were done, I believe there was about 30 feet of piping, of plumbing that was corrected. And it was an extensive repair. So prior to that, I believe it was the plumber had told us that it was snaked so many times that the pipes had been damaged, and that's what was causing the sewage to be leaking. Here's our cost accounting, which accounts for 22 hours and 75 in total staff hours, for a total of $8,894.38. I have prepared a draft FCO for your consideration, which is consistent with finding that the administrative and abatement costs exhibited in the cost accounting are accurate and reasonable, ordering that the administrative and abatement costs in the amount of $8,894.38 be placed as a special tax assessment on the property tax roll, and order that the administrative and abatement costs in the amount of $8,894.38 be placed as an abatement lien with the county recorder. This concludes my presentation, pending any questions.
So just for clarification, there are no administrative penalties on this one because the property owner and or property manager complied with the request. Is that correct?
That is correct. Okay. Within about a month, there was fast response after the notice and order was issued.
Okay.
Could you turn it through the chair? Could you go back to that page, the accounting page? Yeah. So I guess my question is, why is it over so many years?
Well,
Starts in 21, and then there's charges in 22, and then nothing in 23, and then a bunch in 24.
Well, there was a few officers that are no longer with the county that was dealing with this case in the past, and I believe the owner's uncle, who was acting as property manager, was doing what he could to remedy the situation, but as time persisted, it showed that the issues were a lot more, I guess, in depth. The issues were greater than something a handyman would be able to take care of.
So you're saying when you first were notified of a complaint, you said that they got on it within a month, but that was just to try to clean it and stuff. And then it just kept being a persistent problem for over 3 years?
Yes.
Before they changed the sewer line?
Over 3 years, multiple tenants had the same issues, and as well as the electrical panel was arcing. So it was deemed as hazardous electrical, and they would have a handyman respond and attempt to fix the issues, but it turns out the issues were a lot greater than something a handyman would be able to remedy. So eventually it led to a notice and order, which caused them to hire an actual plumber, a licensed plumber, and the repairs were extensive.
Additional comments or questions from the board before we go to public testimony?
Maybe after the public.
Okay.
I just had a comment. So they did get the plumber to take care of all this at their own cost. There's no county cost in that?
That's correct.
Okay, thank you.
Okay, is there any public comment or public testimony on this? We'll open the public hearing.
Hello, everyone.
Hello.
So my name is Cam. So whenever I got this notice, issues like in he said like in 2021, and we did fix it, and then we didn't know about it. Like there was a actual plumbing issue, so I sent the plumber over there. They did clean up the pipe, and he found some diaper and stuff. That's what he thought. Like basically, whenever we got the complaints, we did fix it every time. And when the last time we had 2024, and then we called the couple plumbing company around here, they didn't have the actual. We have to put the camera in the pipe. You can see that right in the picture. The camera has to go all the way to the road from the property, which is I think over more than 100 feet, I guess. So finally we find someone. That's why it did take a little longer. And then once we find it, and then we fix the job, as soon as possible. So that's what we stand for.
So did your tenants call you and complain?
No one ever called me.
None of your tenants called and complained?
Yeah, no one ever called me.
They just called directly to the county?
Otherwise, I would fix it right away. There's no reason to be. I manage a few other property. I never have an issue like this. It's a multiple. It's not just only one.
Through the chair, the tenants had notified us that they had been notifying them, and some of the things were fixed, some were not fixed. When we visited the property in 2022, we saw that the tenants didn't have plumbing in one of the bathrooms, and they were defecating in a plastic bag because it wouldn't flush. And that was how they used the restroom.
When was that, sir?
2022.
2020, yeah, there was in 2021. I remember there was a COVID time, And then everybody's, nobody can get into the places, you know what I mean? So I remember that issue, but we did fix that as well. And it was hard to find plumbers, so everything was so hard to find it, basically. I mean, we did our best, that's the only place we have an issue. I mean, it's not like we did something wrong. I mean, all we can fix as soon as we hear something.
Through the chair, Jeremy Strang. So I just want to make sure that, I'm not sure, are you the property manager? You're not the owner, correct?
No, I'm the property manager, yes.
Okay, just wanted to, for the clarity of the record. So a couple of things. I want to make sure that we stay focused that this is a cost hearing, not an appeal hearing. So the time and place in which to argue the nature of the nuisance or perhaps even the response has passed. So your board doesn't really get to consider that today. However, in order to determine the reasonableness, we show you, illustrative examples of what the violations were. I want to point out one of the questions earlier, I think Supervisor Messick, you had asked the time frame. And so remember, we, as a policy, try and remedy these code cases that we receive complaints on at the lowest level, which means we're going to work with the tenant, we're going to work with the property owner. That was the case. So each time an issue arose, there was a response, but the response wasn't sufficient. And because it was a reoccurring problem, it took a notice in order to abate to get the line scoped to find that the damage was much more extensive and that a simple roto-rooter would not fix the problem. It had to be a replaced line. And so, again, there were a number of years where a number of officers had responded out for very similar, if not identical issues, but it was the notice and order which caused the final response by the property owner, and we appreciate their response. But staff time associated with code enforcement's activities are listed here in the sheet. And part of what the ordinance requires, of course, is that we bring our costs to your board for confirmation as reasonableness and accurate. I hope that provides a little clarity.
I have a question, Jeremy, through the chair. So it looks like to me the total was $37,3275, and you sent the demand for payment, I'm assuming, in that amount?
Well, Supervisor Messick, the staff time associated with our response over the years is 22.75. In fact, let me kind of talk about that for a moment. So our administrative record contains over 100 entries, and you don't see 100 entries here. So we didn't bill for all of our staff time associated with this particular case, only about 22 or 23 hours. And then your board also every year adopts a fee schedule for all departments within the county. So some of these, when they say fee there underneath, those are fees that your board has adopted that the department applies to any code action or response, very similar to any other department. So you have staff time, and that's where we're actually going out and doing something's well defined in the ordinance, what staff time relates to, or enforcement costs. It's defined in multiple areas. And then you have the fees associated with an activity.
Yeah, but I guess what I'm getting at is 7/23/24 demand for payment and cover letter was sent out.
Yes.
What was the amount on that demand for?
The demand, I don't know that we'll have that here. So this cost accounting sheet is based on that final demand. Mm-hmm. And the addition will be the amount of staff, the fee associated for the cost accounting hearing, and then any future documents that will need to be recorded. And the reason we do that, and there's a rationale behind it, because what happens is that people will come back years later and they don't want to pay for our staff time to do the research, create the document. So we bill it at this point. And so it's those three charges that you see that it will be the cost accounting hearing before the board. It will be the notice of compliance and the release of abatement.
I guess what I'm getting at is when you sent them the demand before you bring it to us, it's for probably the 3,700 and 3,275.
No, sir.
No?
No. It will be about $2,000 less.
$2,000 less. And do you also state in there that, hey, if you don't come and work this out with us and make a payment plan or pay us, and we have to take it to the board, it's going to be an additional $2,000?
In fact, we do. And,
Okay.
and in fact, there were some negotiations just yesterday about this where it's my understanding, and I don't want to step on Anthony's toes here, but that someone came in to make a payment and we had reduced it down to, because your board, specifically you, had asked that previously, that if we don't come to hearing, can they save those costs? So we said, sure, if you come in and make full payment by, we had tried to do it prior to, but it was down to the last minute, and they came in last night at 10 minutes to 4. The payment didn't get made, and so here we are. You know, even with that, Supervisor Messick, the work that goes into bringing it to hearing, you know, we may only be here 15 minutes on average. And so the bulk of the work is in preparation for getting it here, not necessarily the delivery to your board, if that makes sense.
Yeah, I just getting at the fact that we are offering, the county is offering people, you come in and resolve this, you can save yourself a couple $1,000s.
We always try to resolve, absolutely, and it's a fantastic point, and we always try and resolve it as quickly and as easily as possible and save the board from having to do this. It's certainly their right to be heard by your board, but, you know, if they can save money, our goal isn't to collect money, our goal is to abate nuisances.
Yeah. All right. You have anything else to say?
So yes, so first of all, I'm going to clear this, and that is she's a property owner, and her health was, you know, was not okay for the last couple of years. Her manager is also here. She can, so the other part I can explain, the way she said the payment demand was, you know, yesterday. So I came here before on time, and payment was already, like, I have a check ready to be given to them. They already accept the check. And then I guess after Miss Dina, and then she called that the person who was accepting the payment. There's a check supposed to be 88 something, and I was like, you know, why is it 88 something? Because that's after the hearing. So that was the whole reason I'm here, to be paying this fine, to be, you know, so we can cancel this hearing. So you know, I don't have to be pay extra charges, right? They were not listening. They refused that. And then they give me my check back. And then after that, I got the email after 5 o'clock, which is 5:39. So if you guys can call us. So 5:39, I also left for the day because I have another night duty to go where I work for a trucking company. So I told them, so now I'm already left for the other job, and then I'm going to come back in the morning, like not till 10, 11 in the morning. And I was ready to make a payment, which is, they were saying I was not, you know, they already set the check. So.
Did he come in yesterday?
It was correct, sir? Like, you know, you can.
That is correct. I was notified that he did come in. There was some error in this, and the amount was unintentionally given to him for the amount after the cost accounting, when the agreed amount, if he pays prior to this. And he was even notified this morning that if they paid online, they'd have the option to pay online before the hearing, and it would be the $63.30 and 17 cents. However, he declined and wanted to take it to the hearing.
Yes. Sorry, mic's back on. I think our department had a really good point that a lot of what they do is to prepare for the hearing. That $1,800 fee is to prepare the time it took to prepare for today, and to put the team together and get them here and get them out of their other duties, assign other staff to duties, and waiting till the very last minute of the last day to cut the check, you risk running into issues. So for me, for the people that live in the home, who made the complaint, who've dealt with this for 2 years, taking it down to the last day, that doesn't really help me side with the owner. So
I have a difference of opinion. If they have a deadline and he actually made it an hour before the deadline, sounds like he's at 4 instead of 5, and there was confusion and code enforcement's office to not accept the 633073 and didn't email him back till after 5:30, then I would think that he made a good faith effort to make it before the deadline, and I would be okay with charging him the 633073 if he pays today.
So in following up on that, because it sounds like there was a discussion to pay today and online, and that was declined. Is that so?
That is correct.
So there was an additional kind of outreach today.
Correct.
And an actual, not just sending an email, but there was communication back and forth.
Right.
And that did not work out. Is that correct?
Correct. We gave him the option to pay last night online or today before 1300 or 1 o'clock today, and we'd pull it from the agenda. And he declined so he can speak.
Through the chair, can the gentleman please give his full name for the record?
Oh, sorry.
Your full name for the record?
Harkamal Singh, Harkamal.
Anthony, was that done via email or?
Through the chair, no. That was actually, Officer Mays contacted him last night. I believe that might have been through email, but today we spoke to him on the phone, or Karen Preet on the phone.
They spoke to you today on the phone?
I actually called them because I found out today what was going on. So I wanted to communicate because of my health issues. My family didn't want to put any stress on me to let me know what was going on. And when I called them to ask them if we can get some time or if we can make a payment on the thing because of my medical bills, I won't be able to afford the whole thing. They said, you're too late for that.
What time was that phone call?
We attempted to contact them around 9 o'clock. We left a voicemail. I called around 10, and I believe she called back somewhere around 10:30.
And I didn't know if they even called. My manager suggested me. I didn't even tell her my work. So we're out of work right now, trying to get this all sorted.
So I guess I'm a little bit confused. I'm going to clarify with you. You came in yesterday at 4 with a check prepared to pay $63.30 and 73 cents.
Yes.
Yesterday.
Yes.
And then you talked to him this morning and said you wanted more time to pay or you want to make a payment plan.
That's right, because he's trying to pay out of his pocket for me.
Okay.
Could you please speak into the microphone so we can make sure we're capturing your testimony? Thank you.
I don't want to belabor this any longer than we have to, and I apologize, but I just want to make a couple of things kind of clear. So the demand for payment, and this is Jeremy, just for the record, was mailed out in July of 2024. So we're not talking about a day here. Yesterday it came to a head and it was the final 11th hour. We got to get this done. I've heard a couple of different stories myself. I know that the system had the right amount in it. So, code enforcement does not sit in the government center. It sits at the sheriff's office, but we take our walk-ins and our payments here at the government center. And so can there be confusion? Absolutely. But all this was out there a long, long time ago. And so we are talking about the 11th hour and some confusion occurring because people still, as I understood it, wanted to make payments yesterday. And the deal is that we will waive the $2,000 if you get it paid and we can pull it from the agenda. That the fact is that didn't happen. And if there was some confusion between staff and our customer, if you will, that's unfortunate. But I do want your board to realize that this didn't happen overnight. This has been brewing for a long time. We did our best to help themselves, and we ended up with having to issue the order, which puts us in front of your board, which is the contentious part of this. And so I'll leave it with that. I just don't want there to be any confusion about this happened last night or yesterday or whatever the deal was. This has been going on. There's been, when I say deals, that means we're trying to make arrangements to where, hey, can I make payments? Yes, you can. We will accommodate you. That doesn't happen. It takes us from July all the way till March of this year to get before your board. And then at the last minute, hey, can we do this? No, we've already done the work. It's on the agenda. We're moving forward. I realized there was some confusion last night. I'm not sure why there was confusion. It was in the system correctly. There's an administrative record in the system that said this was what was told to them. And so there was a disconnect. I believe that. But everything in the system was correct. And I hope that didn't create any more questions. I hope that it just kind of settled this idea of this last minute, that it's not the last minute.
I'm going to stand by my statement. It sounds to me like we had an error made at the county, and we're here to serve the public and the taxpayers of the public. And I think that we ought to honor that we, even though it was within an hour of the deadline, we ought to honor that we made a mistake and lower it to 6330.73. I'm going to make that motion after you close the public hearing.
Okay. Any more public testimony or board testimony? I'll close the public hearing and entertain a motion.
I will make a motion. Can you put that screen back up there? I'm going to make a motion as recommended, but change the amount to $6,330.73.
Is there a second? Okay.
I'll second.
Oh, okay. There's a second. Roll call vote, please.
Supervisor Vasquez is absent. Supervisor House.
No.
Supervisor Fuhrer. Supervisor Bradford.
No.
Supervisor Messick.
Yes.
Motion does not pass.
Okay. Is there an alternate motion?
I'll make the motion that we wipe the penalties completely and they owe nothing.
Is there a second? Okay. No second. Okay. Motion dies due to lack of second. Is there another motion?
I'll make the motion. I move that we adopt staff's recommendation, facts finding conclusion to law and orders as written, and approve the amount of $894.38.
Is there a second? Okay, I'll second. Roll call vote, please.
Supervisor Vasquez is absent. Supervisor House.
Yes.
Supervisor Fuhrer.
No.
Supervisor Bradford.
Yes.
Supervisor Messick.
No.
Motion does not pass.
Okay. So with no motion, with no passed motion, I assume it will need to come before the board again, but that would require additional costs to the individuals, or what? How would that work?
Through the chair, the work has been done, so I wouldn't envision any additional work that would increase the cost. So I guess if the motions all fail, as they have, then I don't know what ability we have to bring it back, and if we do, to have a fifth board member that can break the tie.
Yeah, I think council can weigh in on this, but whether we can continue to a time certain and whether we could do that without additional advertising costs.
Yes.
I would recommend you continue the public hearing. Did you already close it?
I can reopen it.
Reopen it, and then it would be continued, so it would remain open until that next meeting.
Okay.
Through the chair, just as there should probably be no other communications between staff and anyone regarding this hearing. Would that be accurate? In other words, I don't want a dialogue to occur between an officer and the property owner outside of this hearing remaining open and continued. If I'm incorrect on that, just say, no, it doesn't matter.
Well, if it's continued, to me, it's kind of like it hasn't happened yet. So if they want to come in and try to work out a payment plan or a schedule with you guys, why not? Not have to bring it back to us. That's what we're kind of encouraging. That's what we've been encouraging. So we wouldn't want you to not have a dialogue with them if they want to come in and try to work it out and get it done and not bring it back to us. That's that way you guys understand we've always been trying to encourage.
Thank you.
What do you think, Janet?
I'm not aware of anything prohibiting
Okay. Just wanted to make it sure that we weren't going to engage in something that we shouldn't. That was my.
I'm open to hearing if someone's aware of anything that I'm not aware of. Chase, are you aware of anything?
Okay, so
We haven't opened it back up yet.
can I believe I can continue this item until 1:30 PM on March 25th?
Did you open the public hearing back up?
Yes, I did.
Okay, so you have a public comment.
Oh, okay.
Thank you. My name is Ruth Armstrong. I'm here as Karen Preet's manager, her office manager. I would like the ones that voted no against the 6,000 something. I actually like Seth's idea in this case. Karen Preet has been dealing with some medical issues. She is buried in medical bills. And I think it would be to the board's, I don't know how to say it, but I think the board should show a little grace here. The work's been completed. I feel in a timely manner after looking at the time span here, why, again, like Mr. Messick said, from 21 to 2024, I can vouch that last year, she was pretty much out of the office and bedrid due to medical issues. And I really think it would be nice if the board would show a little grace on the fees on this due to the circumstances at hand. So that would be what, and not just know and look at a bunch of codes, look at a person in general who's made an effort to comply and basically is now getting extra charged for coming in front of you when things couldn't be resolved yesterday because of the staff error. I think to say $88.94 and 30 cents is kind of ridiculous penalty because of a staff error yesterday. So I would just encourage some grace be made and maybe a possible motion made to get this resolved. Thank you for your time.
Thank you.
Through the chair, I'd just like to point out one thing. There is no penalties involved in this case. This is all the costs of staff hours.
Thank you.
I'd also like to add Anthony and Jeremy, just so you guys know. I'm not saying reduce it because you guys made a mistake. Obviously, that was made here in the office here, you know, and again, like I say, and we're here to serve the community and the property owners of Yuba County. And if somebody here made an error, I'm going to stick with my ground that we shouldn't penalize these people because somebody in our county government staff made an error or a misquote. That's it. Not holding against you guys. I don't think you did anything wrong, but somebody along the way dropped the ball.
Part of me, the officer wants to speak because she has information that she believes will help you arrive at the 8,894, but we continue providing you with evidence and testimony. I suppose that code enforcement could even modify its recommendation to meet what Supervisor Messick that you've asked for, and that might make it easier on the board. At this point, I'm not sure what the best course of action is. When you say a mistake was made, there was no mistake because the amount was the amount that was sent for the notice of hearing.
Right. It wasn't a mistake. It was he came in with his check prepared to pay that amount, and whoever he was going to pay that to said, no, it's got to be $88.94.38.
Through the chair, does he have the check with him today? That check that he had with him yesterday?
Well, I think we agreed to everybody said he did come in with that check, right? Both sides agreed to
And then
that?
also, and then the staff was in the office and they confirmed twice with the Dina. Twice. And that was the whole reason she called me after 5:39. And that was a surprise.
So through the chair, we'll let, Dina has been sworn in, Officer Mays, and we'll let her give her.
Thank you, and excuse me, I have a cold. I think that it might be helpful if you know a few more facts of the case. I've been involved since May of '24. When I was assigned the case, the tenants had surfacing sewage on their side yard for 6 months. The property manager, Cam, was the one that I spoke to, and it took me issuing an order to get the plumbing scoped. After they corrected the problem, I have to go back. I could not communicate with Cam any longer because he kept arguing with me and we were not getting very far. So I asked to speak to the actual property owner, Karen Preet. Once that happened, the case moved very quickly, and I was very appreciative for her cooperation. So as soon as we closed the case and sent the demand, I offered her payments. This was in September, to make 2 payments for the 58 at that time. We spoke every month, no less than 5 times per month, about the payment plan up until yesterday, when I was told it was Tony, her brother, that went in to make the payment, and that he told the receptionist that I said he can make payments. I advised that that was not the case. I did call him yesterday when I got home because there was an error. And then I spoke to Karen Preet this morning and I apologized and said, if you still want to make the full amount of the $6,600, you can. She told me she was going to call her father and then explained that it hadn't been her that I was communicating with. It was multiple people within the family. So I really do try to work with the community members. I try to take every step I can to help them along the way, but I certainly cannot know if I'm emailing Karen Preet or Cam or Tony or her dad, but they were given the opportunity to make the 2 payments. And then again this morning to pay the $6,600. And that's all that I needed to say. I did speak to Karen Preet, property owner.
Yeah, again, I know you guys go above and beyond and over the top, but I think my whole issue is if he did go in yesterday and the question was asked, do you have that check with you today?
For the same check?
For the 633073.
Actually, it should be, I still have it in my office. I rip them off.
Okay.
Yesterday. After I went, I'm pretty sure I have those little pieces, but even the staff knows I was here. And then she knows I was here. And then I do have an email that she reaching me out after hour, at 5:39. And then, we did even work. That was not an easy job, to get it done overnight. Things take a time. And then they need to be understand. We'll try our best.
Well, I think they gave you plenty of time. If the tenants had raw sewage for 6 months, they gave you more than ample time. My only concern of the whole thing is that if you, being a property owner, did go in and attempt to make the payment yesterday, and then we didn't accept it, we being the county didn't accept it, and gave you this wrong amount, I would like to make those amends and accept that amount. Standing with what I said before. So unless anybody's going to change their vote, I guess we're going to continue this.
So I think we'll continue the public hearing till the date and time mentioned, and then it is appropriate to adjourn the meeting. Is that correct? Let's make sure I state it correctly.
All done with.
Yes.
Yes, so we can adjourn the meeting. We've continued this public hearing. So yes, you can adjourn today's meeting.
Okay, great. Thank you.
So you understand? So you understand?
Yes, thank you.
We have to come back in 2 weeks.
Thank you.
Okay.
Recording stopped.
Yuba-Sutter.live's local government live streams are presented by Plumas Lake Self-Storage in Plumas Lake, where lifelong local residents are helping other residents keep things safe, providing indoor storage units, outdoor RV and vehicle parking, moving supplies, and Penske truck rentals. Details at plumaslakeselfstorage.com.
Hi, I'm Neil Goforth of Comfort Keepers of Yuba, Sutter, and Nevada counties. Caring for elders or even yourself has challenges. Comfort Keepers of Yuba, Sutter, and Nevada counties can help you address today's issues and plan for tomorrow with in-home and specialized care for you or your family members. Call us at 530-749-8800. Comfort Keepers of Yuba, Sutter, and Nevada counties.
You've seen signs marking some of the gyms in Marysville. They're produced by Sapphire Sign Company, providing something small, large, and mobile. With decades of experience, Sapphire Signs has pioneered local production of a variety of signs, like temporary campaign-style signs, welcomes for unique events, building signage, event promotion, and vehicle customization. Need a sign? Make it a gem from Sapphire Sign Company. On the web at sapphiremarketinggroup.net. Sapphire.
Yuba-Sutter.live. It's the truth that comes through.